Good afternoon, everybody. My name is Chris Justice. I'm here again today to join you guys for another Q&A session where I will hopefully be able to answer as many of your employment law related questions as I can. If you don't know already, operate out of the law firm's Toronto offices. So that's my primary area of practice, but we do have offices across the country, including in BC and as well in Calgary. So if you find yourselves in those provinces, just keep that in mind. But otherwise, again, I'm happy to answer any questions related to employment law that you have. I know that the hot topic still continues to be the COVID-19 pandemic, policies relating to the pandemic, vaccinations as well. I know a lot of you have also been working from home since the pandemic began. And I just wanted to start today with a couple of quick notes regarding employees who work from home. So if you find yourself, for example, as someone who's been working from home since the pandemic began, and you're in a situation where your current employer is actually asking for you to come back into the physical workspace, as an employee, you may feel as though that isn't necessarily something that you want to do. Maybe you've proven that you can do your job from home entirely, but your employer is still insisting that you come into the office and return to the physical workspace. And I want to let many of you know that there may be circumstances in which your employer can actually require you to come back to the workforce, or I should say the physical workspace, even though it may practically be possible for you to perform your job at home. And part of the reason for that is because the term of your contract may be that you go into the office every day, say 9 to 5. And unless there's something specifically in writing that speaks to your ability to work from home, and even though your employer may have granted you a temporary exception while the pandemic has been going on, it could still nonetheless be an issue for you to insist that you remain working from home. And as I mentioned, your employer may have rights or the right to call you back. And if you don't go back in certain circumstances, you may be deemed to have abandoned your position. So if you're an employee who's working from home and you're facing pressure from your employer to return to the workforce, you first want to definitely get in touch with a lawyer before you make any action or before you respond to that employer thinking that you can remain working from home, because you may not exactly have as much leverage in that respect as you would otherwise think. So if you find yourself in that situation, definitely want to get in touch with a lawyer, get some legal advice before deciding to respond to your employer, or perhaps before deciding to refuse to go back to the workspace. If you're someone who's working from home as well, and you've had to take a pay hit as a result of working from home, or you're being offered a position from home, but are being asked to, or being basically told by your employer that you're going to get paid less, do not think that you have to accept that. It is not necessarily the case that just because you're working from home that your employer has the ability to then change the compensation structure of your employment. And of course, before you do agree, hopefully you haven't already, to a change like that in the context of a work from home situation, you'll want to get in touch with our law offices as well, to make sure that, first of all, to ensure whether or not your employer even has the right to do that. And secondly, to give you an idea of what your options are if you choose to object to the pay decrease, especially if it's going to be a significant change to your compensation. That said, I'll get into some of the questions. So please do send in your questions. May be COVID related, may not be COVID related. Just send in anything and I'll do my best to get to it if I can. So I'm going to start with a question or a comment from Nightmare Girl on YouTube. And she is asking, if I'm under Directive 6 and I consent to testing, and I have been tested, but now I get fired for not being vaccinated, am I owed severance? They said their policy change is to be construed as a notice period. Okay, so this is a good question regarding those who fall under Directive 6, and also regarding those who may have been doing the testing and are now being told that that is no longer acceptable. In the context of Directive 6, as far as I'm aware, the option is given for employers to have policies that um, offer either full vaccination or testing. And so, in my view, an employer who is going to comply with Directive 6 is going to provide the employee with those options. And if that has subsequently changed and is no longer the case, and the employer is now only offering one option, and Directive 6 is still the applicable legislation, then I think there's a very good chance that by forcing you to get vaccinated, and if you were to lose your job as a result of that, that you would be entitled to severance and potentially other forms of damages as well. So this doesn't just apply to Directive 6. This applies, I think, to most industries, if not all, where there's been a change in the policy from offering an option to test to then switching to full vaccination. If you're an employee, generally speaking, and you've done testing, and now you're being told it's no longer sufficient, and you're being told that your job may be lost as a result of your refusal to get vaccinated, then definitely get in touch with our law firm and speak to us, because it's highly, highly likely that your employer cannot force you or implement, I should say, a mandatory vaccine policy requiring a vaccination, whether it's under Directive 6 or otherwise. So if those circumstances change, you'll definitely want to get some legal advice as soon as you can. Now, you raise another point about notice period. So I want to talk about the concept of a notice period, a working notice period, because there are a lot of individuals and situations that I've come across where people are being told, for example, that if they are not vaccinated by the end of the year, that they will lose their job. And assuming that they get paid until that day comes, that notice period, that sort of heads up that your employer gives you about losing your job, depending on the circumstances, that period of time could be credited, I say, towards the employer for providing you with notice. So, for example, let's say you as an individual are entitled to 6 months of severance, and your employer gives you 1 month heads up that you will lose your job if you do not get fully vaccinated. And so you refuse to get vaccinated, you work that month, you get paid for that month, and then when that month comes up, you lose your job. That month, as I mentioned, will in many cases be credited towards the employer, so that if you are, say, entitled to 6 months and they gave you a month of heads up, then that could mean that you're only entitled to an additional 5 months of severance in the hypothetical that I used. So hopefully that answers your question from YouTube, the question I got from Nightmare Girl regarding what they meant by the change being construed as a notice period. So they're trying to get credit now for that notice being given. But I wouldn't assume that they will be given credit. That's just something that you'll have to discuss with us on a case-by-case basis to find out whether or not that kind of a heads up or forewarning, for lack of a better word, would be credited towards the employer when it comes to your severance entitlements. I'm going through some more questions, so bear with me, everyone. So I've got a question in from Denise on Facebook. And Denise is saying, so we can't even collect unemployment insurance if we are forced to go on a leave of absence without pay, losing my job in 3 weeks. And this brings up another important topic, and that is EI benefits and what happens to someone's EI benefit entitlement in a situation where they are terminated due to failing to get vaccinated, or where they are placed on an unpaid leave of absence for an undefined period of time for refusal to comply with a vaccine policy. A lot of people right now are in this situation where they're either in limbo and they don't know necessarily if they've been let go, or they've been terminated for just cause for failing to adhere to the policy of their employer. And what I would say to those people, first of all, is that if you are looking to get EI benefits or you are thinking about applying for EI benefits, that you should definitely do that. You'll either be told by Service Canada that you qualify or that you don't. And unfortunately, it seems like a lot of individuals are being told, and this depends on the circumstance, but are being told that they are not going to be receiving EI if their lost job has to do with a vaccine policy. Now, if you're someone who's been told that from EI, I wouldn't say just to give up at that point. And in fact, there are appeal mechanisms in place where you can dispute that refusal from Service Canada to provide you with those EI benefits. And so that's also something else, however, that you'll want to get in touch with a lawyer on, and something that we may also be of assistance with in trying to get you those EI benefits, in trying to get your employer to change perhaps your record of employment to reflect the fact that you were not let go on a just cause basis. So there's some options there. I wouldn't give up, but definitely get in touch with us if you find yourself in a situation where you're having difficulty getting approval on the EI benefits side. But definitely don't assume that just because you're in that situation that you don't have those options. So keep that in mind. I think that's very important because I know a lot of people are applying, and I think it may hopefully just come down to just being a little bit more persistent than anything, and not necessarily going away at the first sign of refusal on that end. But thanks very much for your question, Denise. I appreciate it. And Denise, if you're losing your job in 3 weeks as a result of your refusal to comply with your employer's vaccine policy, then I would definitely suggest you get in contact with us, because again, there's a good chance that you would be entitled to both severance and potentially other damages, depending on the circumstances. So Denise, thanks again for your question. I've got another question in from JC, 2004 on YouTube. He or she is asking, what percentage does the firm generally charge on settlements? And JC, that I can't really say in general. It'll come down to the situation. It'll come down to your particular case, how much risk there is, how much of an anticipated battle, for lack of a better word, that there might be with your employer, whether litigation's going to be a necessity or not. So JC, if you're wondering what kind of legal fee structures we can put in place, I would say call in, let us know what your matter is about, and if we can be of help, I'm sure we can work out something that benefits everyone. So thanks though for asking that question. Denise is following up with a comment from her earlier question, just commenting that her rights are now at 0 and that there's no Charter of Rights and Freedoms. I appreciate your frustration, Denise. It's definitely a tricky sort of time that we live in. There's a lot up in the air right now. I wouldn't say, however, that your rights are 0. I don't think that there's necessarily anything anyone can do to practically stop their employer from doing a certain action or performing a certain action, but that doesn't mean you don't have rights. It just means that while you may not be able to prevent what's to come, that you just need to, at that point, shift your focus to what your rights are, what your options are. And for the most part, those who are affected negatively as a result of these COVID policies will likely have rights. Rights in terms of severance, potentially rights in terms of human rights discrimination damages, bad faith damages. So especially if you're a long-term service employee who's put in a lot of years, I would definitely look to pursue that and do everything you can to do so. So hopefully that alleviates some of your concern, Denise. And again, if you have some particular issues in your case, feel free to give us a shout, and we'd be happy to take it from there. Sorry, guys, just getting a lot of other questions coming in. Forgive me for not getting to everyone. Bill on YouTube, Bill Sullivan, he asks, or rather says, that he was fired for reporting harassment. Would this qualify as a constructive dismissal? Well, Bill, if you were terminated, as it seems like is the case, then it wouldn't be necessarily a constructive dismissal. It seems like it's just simply rather a very straightforward termination. The question, though, may be, why is it that you were terminated? because if you or anyone is terminated or loses their job for reporting a legitimate instance of harassment, then not only would you be entitled to severance, but potentially you would be entitled to additional damages for the retaliation that you faced as a result of reporting that harassment. Now, I don't know if the company has a different take on why it is they let you go. And sometimes these cases can be tricky where someone is let go after shortly after reporting an incident of harassment, and it seems very obvious to connect the dots. But it's not necessarily always obvious. So I would say, Bill, if you nonetheless find yourself in that situation, you may want to get in touch with us so that we can flesh out some of the facts a bit more and just find out exactly why it is you were let go. Because unfortunately, this does happen where people face retaliation, they face reprisal, and they have significant rights as a result of that. So definitely not to say that you don't have options or rights in this case, Bill. I would say get in touch with us and we can, like I say, fully flesh out the facts of your particular matter and give you the best advice possible. So thanks though for your comment, Bill. Definitely get in touch with us either way. I've got some other questions coming in. So I've got a comment or a question from Steve Beard on YouTube. Steve is asking how the OSHA, so I think he means the Occupational Health and Safety Act, could force this as the vaccine stays with you after you leave the job site. So Steve, I'm not entirely certain what it is you're asking. I don't know if what you're saying, you may be in a situation where your employer has referenced the Occupational Health and Safety Act as a means to justify its COVID vaccine policy. And the Occupational Health and Safety Act does set out various obligations that companies have towards their employees. And of course, one general obligation is to keep the workplace safe. However, do not assume or think that just because the company has cited the Occupational Health and Safety Act in the context of its COVID policy, that therefore, if you don't comply with the COVID policy, you have no rights. I appreciate that a lot of companies, when they're coming up with these policies and when they're telling people that they may be terminated or put on a leave of absence for failing to comply with these policies, I appreciate that one of the legislation, one of the pieces of legislation that's often brought up is the Occupational Health and Safety Act. And there is some sense to that, but that act itself does not require employees in a particular company to get vaccinated. It does not require employees to submit to rapid testing. So the mere fact that your employer might be mentioning this piece of legislation in defense of its position, again, does not mean that you're therefore dead to rights and you have no options. So Steve, if you find yourself in a situation where your employer is pressuring you to get vaccinated further to its obligations under the Occupational Health and Safety Act, don't feel as though that means that they have an open or a slam dunk case, so to speak, and definitely get in touch with us. You've seen the prompts that have come up today. You can get in touch with us in various ways: employmentlawyer.ca, stlawyers.ca. We've got pocketemploymentlawyer.ca. We've got a number of tools and information available to all of you, whether it's COVID related or not. That'll hopefully answer a lot of the questions you have. And again, if you have any further questions, you can feel free to give our offices a call across the country, and we'll be happy to take it from there. So hopefully that answers what you were mentioning, Steve. But if not, maybe you can send a follow-up note. So I'm just going through. Looks like I've got some comments from Douglas Harlos. Douglas is saying you'll have to prove that you were fired for reporting. Oh, what you're talking about is the harassment that the earlier individual was mentioning. Yeah. So Douglas is saying you'll have to prove the fact that you were fired for reporting the harassment, which is of course true if you want to seek damages further to that. And Douglas also mentions documentation from I guess in terms of providing evidence. Douglas, it seems like you're contacting us from the US. So I will say that Canadian and US law is very different. But some of the general points you picked up on in terms of providing documentation and obviously drawing the connection between reporting the harassment and getting fired, generally speaking, that is still the case. That is still relevant. Evidence is, of course, very important. And a lot of times when it comes down to he said, she said, regardless of what the situation is, it can, of course, be very difficult to prove. So putting things in writing, for example, if you're complaining about harassment, filing a complaint in writing, having that record, having that paper trail will be very important, or likely could be very important later on down the road. So notwithstanding, Douglas, the fact that you're in the U.S., those general points still do hold water. So thank you for your comment. Going through some more questions. Bear with me. And I've got a question in from Azael on YouTube. And the comment or the question is, I wish the show would emphasize more on employment contracts that limit you to ESA minimums, as this greatly limits your severance entitlement and will not get you 24 months of severance. And, I'm happy to actually touch on this point right now. I realize it's not about COVID-19, it's more generally speaking. But I think it is important to highlight the fact that in many situations, if you're an employee and you start a job, you are being asked to sign a contract. And you may not think necessarily about everything that's in that contract. You may focus on how much you're getting paid or how much vacation you have or whatnot. But it's very important to acknowledge and be aware of the existence of termination clauses or provisions in your contract. So as Azael points out, depending on the contract you sign with the company and depending on what exactly is contained in that contract, it could actually effectively limit your severance entitlements if you ever are to be terminated in the future. And there's a mention of 24 months. 24 months is essentially the most severance anyone in the country can get and is usually reserved for those with longstanding tenure, those of a more advanced age, and those of a very senior position. But it just underscores the point that 24 months severance as a potential maximum entitlement is very significant. But if you sign a contract that limits you to the bare minimums, you may instead only be withheld to just 8 weeks of severance or of notice pay. So it kind of goes to show that depending on the situation, even someone with 30 years of employment may be actually withheld to just 2 months of notice or severance pay versus potentially getting as much as 2 years. So I take your point, Azael, on the employment contract issue. And I think that perhaps next time I'm on the show, at the very least, I myself will highlight some of the things that everyone should look for when it comes to employment contracts, when it comes to termination clauses, especially going into your employment relationship. Because the last thing you want is to be let go several years down the road and find out, that you signed a contract that effectively limits your rights and you're no longer able to get those potential maximums, which could be very significant. So thanks again for pointing that out, and I'll definitely raise that as a topic the next time I show up. But hopefully that gives you an idea, anyways, of the importance of contracts and the importance of termination clauses within those contracts and how impactful they may or may not be. Fortunately, for the most part, there isn't too many contracts or aren't too many contracts out there that limit you effectively. But having said that, nowadays, it's definitely a more common occurrence and is something to be on the lookout for. Getting some comments in here. Oh, back to the US question. So yes, Canadian employment laws are very different. That's correct, Mark. Thank you for pointing that out. Because a lot of people do think, and especially people coming from the States, think that the employment laws are much different. And in many cases, the employment laws in Canada are actually a lot more beneficial to the employee than they are in the US. And so that's just a general point to keep in mind, but I'll move on to some other questions. I've got a question in from Sammy on Facebook. Sammy is asking, is an employer's policy that mandates vaccine that that result in psychological harm considered workplace violence? And Sammy, I guess it would come down to the specific context. I don't know if you would be able to argue that you suffered psychological harm as a result of an employer's mandatory vaccine policy. Not to say that it may not be possible, but you could face some struggles in that sense. It may also come down to perhaps how much pressure your employer is putting on you to get vaccinated. It may come down to whether or not you are actually threatened in one way or another for not getting vaccinated or not complying with a policy that a certain something will happen. So I suppose to the extent that your employer or individuals within the company are doing certain things that to most people would create psychological harm, then I wouldn't shut the door completely on that. So I just think it would come down to the specific context, who is saying what, and what exactly is being done to you, apart from the fact that the employer is implementing a mandatory COVID vaccine policy. So Sammy, that might be something you wanna talk off the air at a later point about, and you can give us a call at our firm, and we'll definitely look to help you out as best we can. Sorry guys, just going through some more questions. There's a lot here, so just bear with me. I won't be able to get to everything. Lucienne on Facebook is asking, do you take on workplace harassment and abuse? And yes, absolutely. That's something that we deal with, Lucienne. Oftentimes when you are helping individuals who have not yet been terminated, but are just in the course of their employment, you do tend to, at least from my perspective anyways, come across a lot of situations where individuals in the workplace are facing workplace harassment, whether it's sexual harassment, whether it's non-sexual harassment, facing bullying, being targeted in some sense. There are a whole host of issues, of course, that can arise during the working relationship that may impact someone so significantly that they are either considering going off on a medical leave of absence, they are considering quitting altogether, or something of the like. And this just goes for everyone in general. If you as an employee find yourself in a toxic work environment and you are thinking of quitting, or you're thinking of going on a leave of absence with the support of your doctor, just know that before you quit, before you do anything, very recommended to talk to a lawyer, because you could be entitled in those cases to severance as though you were terminated, as well as additional damages if you can make out evidence relating to bad faith or relating to workplace harassment, and especially if you've brought forth your concerns. And this goes back to the earlier question regarding workplace harassment and the importance of documenting things, the importance of providing evidence if you need it at a later date, and obviously creating that paper trail. Because that way, if you've reported workplace harassment or abuse and you have it in writing, and your company, your employer responds in a say a less than satisfactory manner, then you've got that on record. And it just comes down to the way in which your employer dealt with that situation. Did they handle it right? Did they brush it under the rug? Did they condone it in some way? So Luciana, if you find yourself in that kind of a situation, workplace harassment, abuse, that's definitely something that our firm can assist with. And you may want to give us a call, and we can, again, kind of flesh out your case a bit more. I've got a question in from Nelson. It just came in on Facebook. Nelson's asking if a company can be liable for side effects due to the vaccine, which is their mandate. And this is something that I've encountered a fair bit, as far as individuals coming to me and asking or saying, hey, Chris, can they be liable if I develop, say, side effects later on? And the short answer to that really is no, unfortunately. And it's no for a number of reasons, generally. Number one would be actually proving that the side effect or impact came from the vaccine and it didn't come from any external factors, and that can be very difficult if there are a lot of overlapping factors. And then number two as well, the question would involve how much are you impacted? How much did you suffer? Is that something that can be quantifiable? But number three as well is just, I think in general, from my perspective anyways, given the context we're in, given the world right now, I find it hard to believe that someone will realistically have a chance of going after an employer for doing that. So if you're going to be someone who is going to get vaccinated, further to a COVID policy, do not assume that your employer will take on liability, and do not assume that the employer will actually be liable in the future. So do not assume that at all when it comes to your decision. And if you still don't want to get vaccinated, then that's of course your personal right. And if you, again, end up losing your job or lose money as a result of that decision in your particular circumstance, give us a call, because you could be entitled to significant severance and additional money, rather than just being left in limbo on a leave of absence with no recall date in sight, and then having potentially all that time pass and that held against you. So it's better to take action sooner rather than later. And if you have any further questions, as I say, give our firm a call. That is my time, however, today, everyone. I do thank you very much for joining us. Again, do give us a shout online, employmentlawyer.ca, pocketemploymentlawyer.ca. We've got constant Q&As going on. The next one, as you've seen noted down there, Thursday, December 2nd with Alex. So stay tuned for that. And apologize for those who I didn't get to, but hopefully I'll see you all next time. And otherwise, have a great day. Do take care.